And another good evening. It is September the 3rd, 2011. We've made it this long. We got 6 days until the big 911 extravaganza. Wonder what our government's got in store for us as far as a false flag on this grandiose anniversary of 9/11. We know something's coming. We just don't know exactly what. So something will be in the mix, I'm sure, if not before.
Also, I've already heard what's going to happen.
Oh, have you? I hope you're going to be man enough to share it with us.
Obama said he's going to resign.
Gene, if you're on the line there, hit *6 on your keypad on your telephone.
I'm here.
Hi, Gene. Welcome to the show.
Where's
the one and only.
How you doing tonight?
I'm elated. We got the state of Nevada to file. I sent the state of Nevada a copy of the bill in equity, and they filed suit against Bank of America. They're going to shut them down.
Yeah, I understand that was actually your paperwork that did that, right?
Yeah, they filed it August 30th, 2011.
Okay.
We filed the complaint about a month and a half ago. And all of them are following suit. The AIG just filed against they're suing the investors. Bank of America for the investors. This is another Enron scandal. You got to understand, I knew what was going on 20 years ago.
There's a group. Go ahead.
The Enron complaint that was filed in the Enron case. William Davies and Helen Hodges are the two lead attorneys for the investors that sued Enron. Enron was disguising mortgage loans as investment contracts. The banks are disguising investment contracts as mortgage loans. You got to understand what's going on here. That's not my opinion. I'm actually proving it. I'm giving them the evidence that that's what's going on. It's unassailable.
Gene, are you familiar with Richard Fine?
I know who he is, yeah.
He's got a big lawsuit, racketeering, the judicial racketeering down in the L.A. area going after RICO. He's got quite a video out.
This is money laundering, racketeering, but you got to go after them in equity. You can't do it in law. People don't understand equity. I've been brainstorming. I've got 5 of the greatest authorities in the world. I got Austin Scott. I located his brand new 2011 rendition of trust law. I bought it from Aspen. It cost me $2,800. It's the only set you can't. This is like finding a diamond. Austin is considered the greatest authority in the world on trust.
Gene, you're gonna have to bear with us a little bit because as guest 25 here says, please explain equity to us dummies. What's the difference between equity
using kindergarten vocabulary?
Okay, the difference between law and equity, very simple. All law is colorable. Fiction. Why? Because there's no money. They look at form and character. When you bring an action under form and characteristic, you waive equity. It extinguishes equity because the court can't look at substance when you do that. Remember, one of the maxims of equity looks at substance, not form. It looks at intent, nature, and intent. Nature and intent of the litigant. Number 2, equity recognizes beneficiaries, which means that when you go in there at law, on the law side of the court, which is the public side, you cannot bring up trust law because if they don't recognize a beneficiary, they don't recognize trust law. Number 2, therefore you're dead before you ever get started. We're shutting them down. We've shut 20 of them down. Every single one of them without fail.
Now you do that through the paperwork?
Yeah, through the paperwork. We do it. We're in court. When you do a bill in equity, We're not. A court is a place. Everybody has a mistaken notion about what a court is. A court is a place where a contract is made.
Okay.
It's not. All of these buildings that you call courts are privately owned trading companies. They have a DUNS number. They have a SIC code, PIC code, cage code. They're commercial trading companies. They're not courts. We're doing this outside what you call the courtroom. We're convening a court in equity by filing a bill in equity, and they're recognizing it. I got a call from the head legal counsel of the Federal Reserve, and she's treating our bill in equity as a complaint. And are we getting results? You can't believe the shit. You got to read some of the letters I'm getting. I'm getting letters from the OCC, Office of Comptroller of Currency, from the Federal Reserve Board is sending me letters. They're not sending me the letters. They're sending my clients the letters.
Okay. Now you have clients
you
underneath.
Got there. When you hit somebody alongside the head with a baseball bat, you got their attention. Believe me.
How can is there any way people
when you go into equity, if you study what equity is, this is what they did under the King's Bench in 1066. They had a room. The king had a room where he convened court. They called it the Regis Room, R-E-G-I-S. And then what he did is he appointed, because he got overwhelmed, because a court of equity is a court of consciousness. And substance, it takes priority over form. Equity looks at substance, not form. When you go into, and this has been going on for thousands of years, it's not just after 1933, common law doesn't give you a remedy. Equity does. Like if you're going to be an injured party, equity will give you a temporary restraining order before you're injured. If you go in at law, you have to be injured, and then you can get your TRO. But equity prevents the injury before it happens. That's the difference. And equity works on substance. All of these cases involve a constructive trust in equity, which means that as soon as the act was committed by actual and constructive fraud, a constructive trust was created by operation of law. That means that an equitable lien was established, and legal and beneficial equitable title were merged together when this happened, because equity does what should have been done in the first instance. So as soon as they did the act, the trust was created, the constructive trust. They all became constructive trustees, or what they call trustees de centrant, because of fraud. So what happens is titles are merged, a lien is created. You've already won your case if you go into equity. That's how powerful this is. And what they don't even teach this to lawyers in law school. And the Bar Association has managed to hide this from the general public.
Gene, do you have any case numbers or case where any of this can be looked up for verification validation?
Hell yes, I do. I have a equity is everybody. Go listen to Christian Walters. He knows what he's talking about. He's absolutely correct. And the only thing is that taxes are statutory equity, and it's who owes the taxes. And people don't understand tax law. Taxes are interest on principal.
Okay.
When the tax return or the interest is returned back to the principal, you have settlement and closure. And since you're dealing in you're dealing in estate law, until there's an agreement between the beneficiaries and the trustees as to what taxes are owed, and that's what my complaint does. It creates an agreement between the trustees and the beneficiaries as to what taxes are owed. If you don't come in there as the executor or the beneficiary, executor and beneficiary of the estate, then you don't have standing to come into court. Because when you come in there as a beneficiary, you're expressing trust, which is what Christian Walters teaches, and he's absolutely correct. If you bring up the fact that you're a beneficiary, like I go in there and tell them that I'm a beneficiary of the preamble and a constituent member of the posterity under the constitutional trust. The Constitution is an express trust. And since I'm the beneficiary of that trust, and the people that created, and I'm also the grantor settlers created the trust, and I became the beneficiary and heir to that trust. So the judges of these courts of equity have an oath to uphold that constitutional trust. If they don't, they're in breach of fiduciary duty. So they have a duty, a fiduciary trustee duty, to uphold the rights and remedies of the beneficiary of that trust. And that's what I use in my bill in equity.
Gene, we got a question here for you. It says, who is the posterity?
Those were the people that were the original members, constituent members of the, if you will, the colonies. When they adopted and ratified the Constitution, they were supposed to expound on the they were just going to alter the Articles of Confederation and Perpetual Union. They weren't going to change them. But what they did is they extinguished them. Now you're under the Constitution, but the Constitution was a trust, the original Constitution. If you want to get into the racial aspect of it, it's the white races. Why do you think they call the White House the White House?
You know, I'm going to have you take off on that one. Ed from the Clan of Chat, and him and I are in agreement. We go off on this about every call we have, and we're accused of being racist and everything else. But if you take the letter of the law of the Constitution, as I understand it,
that's how they get around the truth, is by calling you a racist. They bring up this, you're anti-Semitic. The word Semitic comes from Shem, which means Semitic. Those were all white people. So what they're doing is accusing you. When they say that you're a racist, they're saying that you're being Semitic. Because people don't know what the word Semitic means. Shem, who was Semitic, was white. The three sons of Noah were all white.
Okay.
So what they're saying is that you're anti-white.
Wow, this is going to be a little bit to get my head wrapped around, because I know, like I said,
go look up the etymology of the word Semitic. It comes from Shem, and Shem was white.
It's
you read Solomon's Songs of Solomon. It says, "My beloved was white and ruddy complected." And he's referring to Jesus Christ. Mm-hmm. Jesus Christ was white and ruddy complected. What does that tell you?
One of our guests here said the original people were French Moroccan. He goes on to say French Moroccan / American Indians.
Yeah, that's correct. The Cherokees, the original confederacy was the Iroquois League, which is a 7-nation confederation. They had the Senecas, the Choctaws, the Mohicans, the Iroquois, the Cherokees, who were all Scot-Irish, formed the original 7-nation confederation called the Iroquois League. That expounded into, that was the predecessor for the 10-nation confederation under the Articles of Confederation. They were all Indian tribes. Most of the plantations in the South were owned by Cherokee chiefs, who were all Scot-Irish. And they came from the Highlands of Scotland originally. And for 300 years, nobody would fight them, because when they went into battle, they fought to the death.
Okay.
We'll study the histories of the Cherokee Indians. Since I'm full-blooded Cherokee, I can vouch for that. I spent 6 years fighting in the ring, so I can vouch for that.